And right out of the gate, boom, the judge isn't mincing words. This isn't the polite, slow build you see in some hearings. This is a legal cannonball into icy water. You won't listen. You sit in jail. But why is this opening blow so important to the case? Let's break down what's already on the line here.
You're going to sit in jail because you can't listen. You're just going to sit in jail on an aggravated stalking because you won't listen.
Good afternoon, Judge Alexander from the People, PNRPA 690.
Good morning or good afternoon, Your Honor. Alyssa Segura with the Neighborhood Defender Service, P86432, appearing on behalf of Stephanie Harris.
All right, and we're holding this exam. Is that correct?
Yes.
All right, I have a plea in the file. I just want to put on the record and make sure it's accurate and that it's been discussed. There would be a plea to the charge of assault and battery with 12 months probation, no early release with mental health assessment, treatment for alcohol and substance use, assessment, batterers counseling, no contact with complaining witness, and then exchange count 1, aggravated stalking, would be dismissed, and obviously count 2 would have been amended in that discussion. And I know you were back with Ms. Harris for some time, Ms. Segura, is that correct?
Yes, that is correct.
All right, and you discussed that plea agreement with her?
I did.
All right, and she rejected it.
That is correct, Judge.
All right, let's do this exam.
One moment, Judge.
Sorry, this is my first time being presented with a copy of the PPO, so I was just reviewing it. No, that's right.
17 served on July 18th.
Okay. Will you just email me a copy of it?
Yes.
So that I have it for my records? Cool.
Judge, I just talked about the defense. They'll stipulate to the PPO where the victim who's about to testify, Bashan Holmes, had a PPO issued against the defendant in this matter, Stephanie Harris, and it was issued on July 17, 2025 and served on July 18, 2025.
Yes, Judge, I just reviewed that and talking with Ms. Harris, we will stipulate to the existence of a PPO that was in place.
All right, so let me just ask real quick, just so I'm clear, was the PPO served and in place on the date this incident is alleged to have occurred?
Let me double check, Judge, but I believe so.
I mean, because
no, because the charge is aggravated stalking, but the stalking of the facts of the case began after served per the witness who testified.
Well, that's what I'm asking.
Yes.
Was she served the PPO before this incident occurred?
She was served and then the incident occurred.
That's what I'm asking.
Yes.
And all right, and that's stipulated.
Yes.
Yes, correct.
All right, any other preliminary matters that need to be addressed?
No, Judge.
Just a mutual order of sequestration if there's anyone present in the courtroom that is potential a witness against Ms. Harris.
All right, and I see the complainant is present, Mr. Holmes. And Mr. Holmes, who's that with you? All right, ma'am, I don't know if you have the potential of being a witness or not. I don't know if you've seen anything, heard anything over the course of this case. I want you to understand, I mean, Mr. Waranga, I don't know if it's your opinion that she is or isn't a witness.
She could possibly, but I would prefer she sits out.
Yeah, and so, ma'am, it's just to, if you sit in here and listen, you're done. You can't testify at trial. All right, pause real quick. Come on up. Detective Oliver, can you raise your right hand? Do you solemnly swear or affirm the contents of these affidavits are true to the best of your knowledge and belief?
Yes, Your Honor.
Okay. And are both of these vehicles currently in custody?
It's just one vehicle. I just provided the court with their own separate copy. So I know you guys usually have a copy.
Oh, one is a copy for me.
Yes, ma'am.
Gotcha. Okay, give me just a second, okay?
Thank you.
My court officers could just make a photocopy of the signed search warrant here so that We have a copy of it for the deputy court administrator. So just make a photocopy before it goes to Detective Oliver. All right, ready? Call your first witness.
Thank you, Judge. Yes, people call with Sean Devonta Holmes.
All right, sir, you're going to come on up to the witness stand here. And then when you get up there, stand and face me. Can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes.
All right, if you can have a seat in that chair there. And I want you to start, sir, by saying your first and last name and then spelling your first and last name.
First and last name is Bashan Holmes. First name L-A-S-E-A-N. Last name Holmes, H-O-L-M-E-S.
Go ahead, your witness.
Thank you, Judge. Good afternoon. Were you at the location of 9425 Linus Taylor, Michigan 48180 on the date of 07/24/2025?
I was currently at work.
And what is that location, though, to you with the incident? And did the incident occur at that location that day?
Yes.
And that's in County of Wayne?
Yes.
And what happened at that location?
At that location, she had arrived.
Who's she?
You say she. Can you please go to that person you identify as she in the courtroom and identify a piece of clothing they're wearing?
Yes, the person that showed up was Stephanie Harris.
And can you please point to that person and identify a piece of clothing she's wearing?
I forgot what she was wearing.
Oh, not
No,
on
not
that
on
day.
that day, today.
Today.
She's in the jumpsuit.
Can
What
you point to
color?
her?
She's right there with the green jumpsuit.
Please let the record reflect the witness identify the defendant.
Record shall so reflect.
And what did the defendant do at that location?
She arrives at the property, attempted to try to get in, took the front camera, dismounted it, threw it to the backyard, and then tried to...
Okay, pause. That single detail, that's huge. Not only does it suggest forced entry, but it also stacks the aggravating factors for stalking. Remember, property damage in connection with a no-contact order is like mixing gasoline with a match in legal terms. But here's the twist. She coned the home. So can you even break into your own property? That's the defense's secret card.
Jump over the back fence, went to the backyard, tried to force entry in the backyard.
Did she damage anything on the property?
Yes, it was the back window.
And
How did she damage the back window?
She damaged the back window with a pick for the fire pit. She knocked out the back window.
in this pick, was it metal or wooden?
Metal.
And when she broke the window.
Yes.
And what was the estimated cost of the broken window?
It's about $1,000.
Less than $1,000 now?
It's about $1,000.
About $1,000, okay. And what happened next?
What happened next? I know I was in contact with the officers about her being arrested, and I was on my way back home to give a statement to the officers.
And did the defendant contact you on and after on the day of July 18th?
Yes.
And when the defendant contacted you, what was the defendant doing to contact you?
Texting.
And how often were they texting you?
She texted me 3 times that day, 9 o'clock in the morning.
And were you responding?
No.
And what was the defendant stating to you?
Stating, please, I don't have nowhere to go, and things of that matter.
So prior to the defendant texting you on and after the 18th, were you two in a relationship?
Judge, I would object to this line of questioning for relevance.
Well, Judge,
It's
if
a
you'll...
charge of aggravated stalking.
Yeah.
How is her contacting him not, and there's a PPO that's been stipulated to, how's that not relevant?
Judge, so I wasn't provided with any information regarding these alleged texts. So I was not put on notice that this was even for the basis of the charge. So that's why I would argue that it's not relevant, because
Do you have the text?
From my understanding, I do not have the text, but I can...
We could testify to him.
Yeah.
He can testify to them. I mean, I'll order that any text messages or calls be preserved. And so if you have proof of those messages that you're testifying to today, you have to turn them over to the prosecutor so the defense counsel can view them as well prior to a trial date. You understand that?
Yes.
All right. But if he could testify to them. Go ahead.
Thank you, Judge. And were you previously in a relationship with the defendant?
In the past.
And at the point of on July 18th, on or after when you received his text messages, was the relationship over?
Yes, it was over.
And you wanted no further contact with the defendant?
Correct.
And the defendant continued to contact you?
Yes.
And you did not respond?
Correct.
And how did this make you feel when the defendant kept trying to contact you and text you?
Uneasy, because I don't want any contact.
How did it make you feel? I'm sorry.
Uneasy.
And what did you do because of the defendant continuously trying to contact you?
I just ignored the text messages from the
And did you get a PPL on against the defendant?
Yes.
Because she was keeping the contacting you. One moment, Judge. And on what date was the defendant contacting you?
She tried to contact me on the 18th, 9 o'clock in the morning. And then that's the day she had tried to contact me. And she also too tried to reach out from jail as well, because I got missed calls from jail too as well.
Contact you from jail as well?
Yes.
And that was after the 18th?
Yes.
Just recently?
Yes, ma'am. Your Honor.
And going to the residence at 9425 Glennis, what is that residence to you?
It's our home.
Our home. When you say our home, what do you mean by our home?
Me and Stephanie's name is on the deed for the house. So we do own the home.
When you say Stephanie, are you referring to the defendant?
Yes.
No further questions, Judge.
Ross?
Yes, Judge. You just indicated that the property that was alleged to have been damaged also belongs to Ms. Harris, correct?
Correct.
Okay. And on the day that this happened, the damage that you observed was to one window pane, correct?
Correct.
It was not, the window had not been fully broken into the home, correct?
Correct.
Okay. And do you remember giving an estimate to the police officer on the day that this happened?
Yes.
And you indicated that it would have cost approximately $700 to replace?
Just to estimate it off the top.
Okay.
Is it estimated cost?
And have you since got a different estimate?
No. I contacted Home Depot to get it replaced and all. So.
Okay. But you didn't provide documentation of that quote yet to the prosecutor's office?
No.
Okay. Additionally, you indicated that she was texting you on the 18th, is that correct?
Correct.
But the text messages weren't threatening, were they?
No.
Okay, it was, you had indicated it was just saying she didn't have anywhere to go
Yes.
because the home that she was, that you guys shared, she couldn't go to, correct?
Correct.
Okay, and the 18th was after you got the PPO?
No, I got the PPO on the 17th, and she texted me after being served.
On the 18th.
So wait, so she did have how do you know she was served?
I know that the officers that night served her the PPO.
At the night of the 17th?
The night of the 18th. That was roughly about 4 o'clock in the morning when they served her the PPO.
So going into the 19th, she was served?
No, going into the 18th.
Okay, so 4 a.m. like morning of the 18th.
Yes.
Okay, and then you said she texted you at 9 a.m. on the 18th?
Yes.
Okay, just once?
3 different times.
3 different times.
Yes.
But right after each other, like I guess what time? First one was at 9 a.m., is that correct?
Yeah, all the text messages was in between 9 o'clock in the morning, between roughly, I don't know, it's roughly around like 9 o'clock in the morning.
Okay, so it was kind of like a text.
Yes,
Okay.
it was a back-to-back text messages.
Okay, back to back. Okay, and then you also indicated that the text just made you feel uneasy.
Yes,
Okay. And you weren't home on the night that you alleged that Miss Harris broke the window, correct?
correct.
Okay.
But on the PPO, it states for her not to
Right, not to
approach
be
the
there.
property.
Right. But you weren't at the house at that time, correct?
Correct.
Okay. I have no further questions, Judge.
Any redirect based on the cross?
None for the people, Judge.
All right, can this witness be excused?
Yes,
Judge.
All right, thank you, sir. You're all set.
Thank you, Your Honor.
Any further witnesses?
The people calling no further witnesses.
All right, any witnesses on behalf of defense?
No witnesses, Judge.
Okay.
Judge, the people, oh wait. Thank you. Walks out. Judge, the people motion to bind over on count 1 for aggravated stalking. As prior to taking testimony by the witness, the PPO was initiated on July 17, 2025. The defendant, per the testimony, was served early July 18th at 4 a.m. morning, contacted the defendant 3 times, and the victim testified that he felt uneasy by this and did not respond to those text messages. And due to the breaking of the window and the ending of the relationship, initiated the PPO, and the people motion to bind over on count 1.
Judge, we would object to the bind over in this matter. For Michigan Criminal Jury Instruction 17.25 for stalking, one of the elements that has to be established is that the contact caused the complainant to suffer emotional distress. Here, all the complainant had testified to is that he felt uneasy. I would argue that based under the statute, emotional distress does not equate to uneasy. Additionally, Judge, what I would argue is that what I was provided, what was testified to, I was not provided. I was not provided with the text messages or any of these allegations that she had reached out multiple times. So I know, Judge, you did indicate that you would order for that to be turned over. I am requesting that to be turned over because they are using that to establish one of the elements. And then thirdly, Judge, while I know this isn't, the misdemeanor isn't warranted a preliminary examination, all I would argue is that under the statute, the charge doesn't survive because Ms. Harris has a property ownership in that property, and so therefore she cannot be charged with destroying her own property. And so I'm not sure if the court is able to dismiss that count, but I would be arguing for that count to be dismissed for that reason as well.
All right. Can I see the PPO?
Oh, yes, let me go get it again. May I approach, Judge?
You may.
Thank you.
And Judge, I would only add that I just looked up the definition of emotional distress under MCL 750.411H. And the definition of emotional distress means significant mental suffering or distress that may but does not necessarily require medical or other professional treatment or counseling. So again, I would say that the testimony did not fit that standard because he just said that he felt uneasy. So that would amount to emotional distress under the statute.
I can make my argument. Judge, in the context of this, the victim stated uneasy, going to the context that the defendant was served with a PPO at 4 a.m. and the victim emotionally fearing or threat or dealing with the defendant took the steps to get a PPO, and in getting those steps to get a PPO was served to the defendant and the defendant still contacted the victim. The words going to uneasy could be in this context go to an issue of the fact of harassment or threatening due to the fact that the facts of this case that the defendant did damage the window with the pick and shattered that. So going to the context and harassed and the PPO, taking it all together in the context of him saying uneasy, that could go to the notion of feeling of the emotion of harassed in this situation based on having a PPO in place where the defendant violated and per the victim's testimony, the defendant has contacted the victim through jail as well and continues to contact the victim after this PPO has been initiated.
Judge, if I just may briefly respond.
Yeah.
So under the statute, emotional distress and harassment are defined differently. So emotional distress is not equivalent to harassment. So I would argue that that point should not be considered. Additionally, though, I did ask him if the messages were threatening, and he said no. So he agreed that he didn't feel threatened in that moment when those texts were simply, please, I have nowhere else to go. Additionally, while I understand that there is a no contact order in place now and we can take up the jail issue after, that wasn't a basis for this charge, this to be charged. That happened afterwards. So that should not be considered in the court's determination as to whether probable cause has been met to establish this charge.
Judge, speaking more importantly, because there's a PPO in place, legally, there does not need to be an actual threat made because the PPO is in place.
Well, that's what the jury instruction reads.
The jury instruction is,
Yeah, the jury instruction reads that.
Yes.
I mean, I think Ms. Segura's argument is just to the element as to emotional distress, which is 4. I mean,
Pursuant, Judge, though, to MCL 750.411I1D, harassment means conduct that causes emotional distress and serves no legitimate purpose. Here, it could be argued that the defendant reaching the victim 3 times, him not responding, and there's being no legitimate purpose put on the record for the defendant to reach out to the victim in this matter when there was a PPO in place would by being legally fit the definition of harassed. With the victim stating he felt uneasy, taken in the context of the situation.
look,
And Judge,
go ahead.
sorry, all I would say is that the harassed is another element. So the third element is that the contact caused the complainant to suffer emotional distress. And then 5th, that the conduct caused them to feel terrorized, threatened, intimidated, harassed, threatened, or molested. So there's 2 elements here. They have to prove that the person suffered emotional distress, and they have to prove that the person felt terrorized, frightened, intimidated, threatened, harassed, or molested. So again, the prosecutor continuously argues harassed, and maybe he did feel harassed, but that's the 5th element. They still have to prove the 3rd element, and that's why I would say they didn't.
Yeah. All right, look, the standard here is probable cause. This is the lowest standard in criminal law. There was testimony from the complaining witness that he obtained a PPO against Ms. Harris. The PPO was stipulated to. The PPO indicates that she was not to return to the property. It also indicates she was not to have any contact with him. The testimony is that even after receiving the PPO, she contacted him on multiple occasions the morning after receiving the PPO. And then a few days later, she went to the home, pulled cameras off the house, went over a fence, knocked out a back window of the home with a fire pit poker. And he testified he was uneasy. Whether or not that means, there's some evidence for this court to consider it a probable cause standard. What happens downtown is a question of fact for a trier of fact. But for a probable cause standard, there's been some evidence of that element, and it will be bound over. So I am, if one of you wants to prepare an order, I want to sign an order as to 2 things. One is to preserve texts and call logs. from the complaining witness that he testified today, if they exist. And the other issue is that, and I know they've done, I'm not going to block all of Mrs. Harris's jail calls at this point, but I am going to block any calls to his.
Think about this. She's literally behind bars for contacting the victim and still tries to contact the victim from jail. If this were a crime drama, you'd call it over-the-top writing. But this is real life. And in court, that kind of move doesn't just sink your case, it buries it with a headstone.
Number from the jail, you're going to sit in jail because you can't listen. You're just going to sit in jail on an aggravated stalking because you won't listen. You won't listen. I don't know what you would be thinking when you're literally sitting in jail on an aggravated stalking case that you would try and make jail calls to the complaining witness. I mean, you talk to her. That you don't want to talk to me. You don't want to tell me anything. But anyone that would think that's reasonable is, So can the two of you approach, please? Ma'am, you're bound over to the Third Circuit Court on the charges as written in the complaint and warrant. I am not amending bond based on the allegations that she's continuing to make calls from the jail, which tells me she doesn't listen to court orders. Second order she's alleged to have violated. One is a PPO and then my order to have no contact. So you're bound over to the Third Circuit Court for all future proceedings, and the arraignment on the information date is that she's in custody.
18th.
What is it?
August 18th, Judge.
August 18th. And if both parties can approach on the order.
What do you think? Was the judge too harsh or exactly right? Drop your verdict in the comments, because your take might just spark the biggest debate here yet. And Have court drama like this keeps you on the edge of your seat. Make sure you smash that like button, hit subscribe, and ring the bell so you're in the front row for the next jaw-dropping hearing we cover.